Okay, then we shall start.
Okay.
Sir, am I audible, sir?
Yes.
Yes, yes. A very warm good morning to all. It is indeed a wonderful day as we all are connected through this two-day webinar on intellectual property rights and entrepreneurial innovation, dated 13 and 14 July. I am Anjan Bharali, Assistant Professor, Department of Commerce, Don Bosco College, Golaghat, Assam. Welcome you all. It was a great pleasure for our Department of Commerce to get the opportunity to host this webinar with eminent and dynamic personalities as our resource person. We were privileged when Department of Commerce, Christ deemed to be University, Bengaluru, agreed to collaborate with us in this venture. Being partner institutes, they were kind enough to have us in July 2019 and again in January 2020 when the Department of Commerce, Christ, invited our BCom second semester students to their campus for 15 days teaching program. We hope to continue this hand-holding and to creating new ventures facilitating the students and the greater society. We are honored to have dynamic personalities with us, with Dr. Chimun Nath, HOD of Department of Commerce, Dibrugarh University, Dr. Avishek Chakraborty from School of Law, Christ, deemed to be University, Bangalore, and also we have experienced and well-known entrepreneurs of Northeast, Mr. Nechute Daulo from Nagaland, Mr. Gopin Moses from Manipur, Mrs. Rita Tage from Arunachal Pradesh, and also budding entrepreneur Mr. Hiranmoy Gogoi from Assam. Despite of their busy schedule, agreed to our invitation and will be joining us tomorrow. Their vast experience and knowledge will surely illuminate the participants. Mr. Kartigai Prakasham, Associate Professor, Department of Commerce, Christ deemed to be University, Bangalore, will also join us as the moderator tomorrow. I feel very happy to say that we have participation from 5 countries, namely India, Indonesia, Saudi Arabia, Philippines, and UAE, and also participants all over the country from 29 states and union territories. The integration of all the participants and the global reach will surely help in making this webinar successful and resourceful. The objective of this webinar is to create a sense of entrepreneurship and idea generation that will lead to self-sufficiency. I request the active participation of the participants and understand the need of the hour to create sustainable ideas and to lead to a better economy. With these few words, I would like to pass the baton to our moderator of the day, Father Bimal Lakra, Vice Principal and PRO of Don Bosco College, Golaghat, who has supported and encouraged us in our ventures. Over to you, Father. Thank you and happy learning.
Thank you, Anjan Bharali, HOD, Commerce Department, Don Bosco College, Golaghat, for putting us into the mood and the atmosphere of this webinar. Thank you very much, and thank you for shouldering the responsibility from the college to organize this seminar. Congratulations to you and to all your fellow colleagues in the Commerce Department. Now we go straight over to the first session of the day, and may I request Madam Devangana Saikia to introduce the speaker of the session. Madam Devangana, over to you.
Thank you, Father Vimal. Hello, good morning everyone. A hearty welcome to all the participants to the two-day webinar on intellectual property right and entrepreneurial innovation. I am Devangana Saikia, Assistant Professor, Department of Commerce, Don Bosco College, Golaghat, would like to take the privilege to introduce our resource person, Dr. Chimun Kumar Nath, Head of the Department of Commerce, Dibrugarh University. Dr. Chimun Kumar Nath is a MCom, PGDBM, and a PhD holder. He has served the corporate sector for 4.5 years before joining the Department of Commerce, Dibrugarh University in 2002. Apart from being designated as Associate Professor of the department, at present he is carrying out the responsibility of the head of the department. He is also the coordinator of the Center for Entry into Services as well as Entrepreneurship and Skill Development Cell. He has presented papers in 114 national and international seminars and has 64 publications in various research journals of repute so far. 7 PhDs and 22 MPhil scholars have worked with him to attain their degrees so far, and few are on card. We are indeed very happy to have such a personality amongst us today. Now, I'd like to welcome you, sir, and hand over to you today's session. Thank you, sir.
Thank you, Madam Devangana, for introducing to us the speaker of the day and the session. Now, may I request Dr. Chimun Kumar Nath to take over the session. Doctor, over to you.
Thank you so much. Thank you, Devangana, for introducing with us such lovely words. Though I'm not basically up to that particular stage here. And good morning to, in fact, good morning to Asia. So many countries are joining us. Good morning to Father Jose. And good morning to all the other members of the team, Don Bosco College, Golaghat. And good morning to all the participants. Well, today I'm in front of you to speak about something related to the IPR. The topic is IPR and the patent part. Now, in the second session, there will be another session of today where Dr. Chakraborty will be speaking to you about how to go for
Mr. Sheila, Mr. Sheila, we'll begin, okay?
Thank you.
I cannot hear you, Sheila. I cannot hear.
Yes, Father.
Yeah,
Yes.
yeah.
Hello.
Put the mic closer because I cannot hear. Okay.
Yes, Father. Okay, thank you.
We are going to begin.
Yeah, yes.
Okay. Hello,
Hello,
good
sir.
morning. Hello, good mornings to all, and welcome back for the second session of our topic today. And the second session is on tools and technique of protecting intellectual property. Now I will request Sister Dr. Sheila Paul, Assistant Professor, Department of Education, Don Bosco College, Golaghat, to introduce to the panelists the speaker for the session. Sister Sheila Paul.
Thank you, Reverend Father Bimalakra, Vice Principal and PRO of Don Bosco College, Golaghat, Assam. We are here with the two-day webinar on intellectual property rights and the entrepreneurial innovation, organized by Department of Commerce, Don Bosco College, Golaghat, Assam, in association with Department of Commerce, Christ Deemed University, Bengaluru, Karnataka. Here, I am extremely delighted to introduce and welcome our resource person, Dr. Avishek Chakraborty, School of Law, Christ Deemed University, Bengaluru. He has done his studies BA, LLB, LLM, and PhD. University topper in BA LLB and LLM program. Awarded Junior Research Fellowship in Law. He has done his PhD from University of North Bengal. At present, he is an assistant professor at the School of Law, Christ Deemed University, Bengaluru. Faculty Coordinator, Intellectual Property Rights Committee. Faculty Coordinator, Internal Quality Audit Cell, School of Law, Christ Deemed University. Presented papers in more than 13 international and national conferences and published more than 11 research papers so far. The areas taught in law school include intellectual property laws, law of copyright, law of trademarks, philosophy of law, jurisprudence, law of torts, and legal methods. We are very proud to have such eminent personality as a resource person for this webinar. A warm welcome, dear Dr. Avishek Chakraborty.
Thank you, all of you.
Thank you,
Thank you,
thank you.
Sheila ma'am.
Thank you,
Am I
sister.
audible to all of you?
Yes, sir. You are very much audible.
Okay. Thank you.
So, Dr. Avishek, thank you very much for joining our webinar. Now that you have been introduced to the participants, can you take over the session and can you speak to us? Dr. Avishek.
Okay. Thank you to the entire organizing committee for giving me this opportunity to present on the importance of intellectual property rights and its different nuances in respect of entrepreneurial innovation. Thank you, Shira ma'am, for your kind words, for that excellent introduction. I will be speaking on certain specific forms of IPR. So I'll share my PPT with you and then I'll start the presentation. Is my PowerPoint presentation visible to all
Yes,
of you?
sir. Yes, sir. Is it on bulbs being burning?
Oh, sorry, Father.
Is it the bulbs? Is it the bulbs hanging and burning? Is
Yeah,
it the...
yeah, that is, yeah, exactly. That is.
Yeah, we can see that. Yes, sir.
Okay, I mean that is pretty relevant. The usage of electric bulb in the initial slide. I wanted to make it sure that all of us understand the importance of intellectual property rights right from the beginning of industrial revolution and back to the history. Thomas Alva Edison was the person, I mean, was the scientist who invented electric bulb, which changed the society, the scientific domain to a greater extent, and that reminds us, and that focuses on having a sound IP management strategy in respect of everyone, especially in respect of entrepreneurial innovation. Now, my objective of this presentation is to highlight the importance of intellectual property as a tool and technique to protect different nuances of business and to help an entrepreneur in the course of his or her journey, and how the entrepreneur can use intellectual property rights not only in case of not only as a legal instrument but also as overall a technique to help in effectively conducting his or her business. So I will start my presentation with 3 stories. Before I go to the details of the presentation, I want to focus on 3 stories and then I will start my presentation. The first one, if you can see that I have mentioned about one Mr. S.K. Matlani. He is responsible for inventing a machine to manufacture mosquito repellent mat. What is mosquito repellent mat is visible on the left of your screen. So Mr. Matlani is from Indore. He invented a small machine to manufacture mosquito repellent mats and started his own business, and he named that as Jet Home Care Products Limited. Now Mr. Matlani invested rupees 3 million for the research and development. He developed a unique repellent that was based on his knowledge of the region's environment, culture, and also his understanding of the mosquito population of that particular area. Now, Mr. Matlani knew that a well-known brand name and image is necessary and essential to his venture to succeed. Although he could have patented his unique repellent formula, I'm sure all of you by this time must be knowing what is patent and what is its use. He decided that the quickest way to establish a strong market presence was to build an image linking the customers and the company with a trademarked brand name. So Mr. Matlani focused his IP management strategy on registering a trademark to create a strong brand name and image, right? Naming his new product Jet, that is JET, mosquito repellent, Jet mosquito repellent, he promptly registered a trademark for this name with the Office of the Controller General of Patents, Designs and Trademarks of India. I'll come to that in details later, but for the time being, this is the IP office where you can register a trademark. Now, this Jet mosquito repellent turned out to be the right choice for a trademark and brand name, as it caught on quickly and became immensely popular, with a name that stood for quality and that was soon knocking on the door of its largest competitors. So we can see that how registration of that particular trademark, Jet, was able to build a brand value surrounding his product. What was the product? Mosquito repellent mat. Although we don't use it now to a greater extent, but I'm talking about the time it is around 1995, 1998, 2000, at that point of time. Now, in 1995, one of India's largest industrial conglomerates, that is Messrs. Godrej Sarali Limited, was looking to enter into the market of domestic mosquito repellent. Now, Godrej found that the quick pace of Jet's growth and the incredible value that the trademark held. Now, Mr. Matlani entered into a lengthy negotiation with Godrej Sarali Limited and decided to sell his Jet trademark for 300 million rupees. Now, why I'm mentioning this particular incident? Now, Mr. Matlani was an ordinary, if you can say, Indian citizen. He was in service. He was an entrepreneur. So his smart vision that in respect of his IP management strategy helped him to get a huge return in respect of his own venture, that is Jet mosquito repellent mat. Now, Mr. Matlani's successful story of creating a powerful brand name is an important example of the vast potential held by the intelligent management of sound IP strategy. The Jet trademark ended up delivering more value than the actual product itself. Now, this was the case for Mr. Matlani, as his trademark registration and IP management strategy turned out to be his greatest asset of all. So this is the first incident. The second incident I want to talk about, I think this particular product does not need any introduction, and all of us are very much familiar with it. But it is an example, it's an excellent illustration to show that how intellectual property rights can help not only an individual entrepreneur, but also a cooperative society. As you can see that Lijat is a cooperative establishment which is established by Indian women that has developed a unique model for development and empowerment for low-income female workers especially. Now, Lijat has more than 40,000 members and has 62 branches across 17 states in India. Lijat was created in 1959 by 7 non-reading but extremely skilled women neighbors who all knew how to make papad-based dishes. Now, Lijat has developed its branding and communication strategy by raising the production standards, developing a niche market identity, and also by creating a variety of products. In order to protect its hard-won identity, while distinguishing its brands and products in a competitive global marketplace, Lijat has relied on the intellectual property system. So what this cooperative did? To this end, the organization registered a trademark for Lijat and Lijat Papad via the Intellectual Property Office of India. Now, Lijat has protected its trade name and identity as a supporter of the rights and causes of women by registering a trademark for Shri, Mahila, Griha, Udyog, Lijat Papad. You can see the trademark on the left hand side, on the top, on the down left hand corner of the slide. For Sri Mahila Griha Udyog Lijat Papad and the symbol of women's strength Lijat Papad, also via the Indian IP office. Now the organization has registered over 40 trademarks for Lijat Atta, fish masala, special Sunday special masala, meat masala, and other products. The organization registered a trademark for symbol of women's strength papad in USA via the United States Patent and Trademark Office. Now it's a very interesting to see that the trademark is registered not only in India but in United States as well. But despite the efforts to protect its IP via the registered trademark, Lijat's popular products have faced counterfeiters who attempted to have free ride on its commercial success. But interesting to see that this registration of trademark by this cooperative actually helped this organization to protect its trademark. So that is what gives us a lesson to understand that why and how registration and protection of trademark is necessary. Now, the women's organization has created generations of employees who are not just self-sufficient, they are also enriching their own lives and those of others in their communities, and to a greater extent, law of trademark has helped them in this respect. Now, the third example I wanted to give is from very our own institution, that is Christ University. And I'm very proud to give this particular example to talk about Professor Saji Varghese. He is an associate professor at the Department of English, Christ University, Bengaluru. He first came across the thought of making straws out of coconut leaves when he noticed several dry coconut leaves lying on the campus ground. So he turned that idea into a reality, and the straws received a patent in 2018. And it's very interesting to note that this patent is one of the India's firstest patent which is granted to an individual. One of the patent which has in a record time this patent has been registered. Now that is what is the significance of intellectual property rights protection, and this IPR protection of the straw from the coconut leaves can potentially eradicate one of the biggest environmental hazards, that is plastic straws. Now this is where we can get the lesson, or we can get the significance or the importance, how having a sound understanding of intellectual property management helps us to have our venture successful and to make our product reachable to a greater number of customers as well. Now, taking cue from these three stories, I will be talking about intellectual property rights, the different tools and techniques of intellectual property rights in respect of entrepreneurial innovations, in respect of business. Now, in the ongoing quest to remain ahead of the competitors, every business strives to create new and improved goods and service that will offer or deliver greater value to the users and the customers than the products offered by the competitors. To differentiate the product is a prerequisite for success in today's market, because the businesses rely on innovations that reduce the production cost and improve the product quality. Now, in the present knowledge-driven, private sector-oriented economic development, the different types of intangible assets of a business are often more important and valuable than its tangible assets. A key subcategory of intangible assets is protected by what are labeled as intellectual property rights. Now, effective use of intellectual property can help to gain and maintain a substantial competitive edge in the marketplace. Therefore, business leaders and managers require a better understanding of the tools of the IP system and exploit the IP assets they own or wish to use for their business models and competitive strategies in domestic and international markets. Now, what forms of intellectual property right will be relevant for for an entrepreneur in respect of his or her business? You can see in the image there are multiple forms of intellectual property which has been mentioned here: trademarks, trade secret, layout design, industrial design, copyright. But based on the theme of this webinar, I will be focusing on certain selective types of intellectual property rights. Now, why I'm selecting a selective types of intellectual property rights, I'll explain that. Now, what type of IPR is relevant for business depends on the competitive space, because patents and trademarks, trade secrets, sorry, these two forms of intellectual property rights are particularly relevant for technology companies. Whereas for consumer brand sector, trademarks and industrial designs are much more relevant. So it depends on what type of business one is pursuing, the relevant form of intellectual property rights will acquire significance. Because trademarks and industrial designs, they mostly focus on creating its own identity, creating its own distinctiveness. That's why it is much more relevant for consumer brand sector. And in case of patents and trade secrets, it is mainly excluding someone from using the patented invention or the relevant trade secrets. That's why for technology based companies, patents or trade secrets are much more relevant. So because it depends on the competitive space, you are stopping your competitor from you are prohibiting your competitor from using that patented technology because you have invested in the research and development, and that's why you are one step ahead of the competitor, and your competitor should not copy and use that invention, that product, without your information. So that is the significance of the law of patents as well as law of trade secrets. So in the present discussion, I will be focusing on trademarks, industrial design, and trade secrets. So these three forms of intellectual property rights I will be focusing on. Now, what are precisely the value of intellectual property as an asset for business? They are having multiple dimensions. However, I'm mentioning few of the value of intellectual property as an asset for business. Many a time we'll see that the intellectual property as an asset, it's all of us know that it's an intangible asset, is much more valuable than the product itself. If we see in case of starting a business, we need to establish the office and the other infrastructure, right? Where and the value of that particular asset, which are of course tangible asset, if you compare that to the intangible asset that runs the company, especially if we see the I mean companies like Infosys, companies like Oracle, right? The intangible asset is much more valuable than the tangible assets of the company. And it is true not only about big companies like Infosys, Microsoft, Oracle, something like that, but also any other new ventures as well, right? So that is the significance of intellectual property as an asset for business. Now, what are precisely the importance? It prevents others from copying products or using the innovations. It creates a strong brand identity. I'll be focusing on this particular topic, this aspect at length later. It helps to obtain valuable competitive intelligence. It helps to gain revenues through licensing, franchising, or other transaction. The example of Mr. Matlani is a good example how licensing helped him to get a big amount of revenue through in respect of his product. It helps to access new markets. It gives you a strong market position and competitive advantage. You are always one step ahead of your competitors. Higher profit or returns on investment is secured. All the three examples which I have cited in the beginning of my presentation is a proof of that. It creates bargaining or negotiating power. So if you have a strong intellectual property protection, it helps you to have an edge, to have a superior bargaining or negotiation power. The first example is a proof of that. It gives you an enhanced ability to acquire finance. and it builds a positive image for the entire enterprise. Now, why and how brand is important? Brand is important from a multiple perspective, right? Now, we see that the value of a brand can be realized from the marketing or consumer perspective because it guarantees the promise and delivery of experience. From a business perspective, it gives the security of future earning because the value is the brand value actually helps you to bring consumers to get access to newer markets. So that is why it's a security of future earning. And from a legal perspective, of course, it's a separable piece of intellectual property. Why I said it's a separable piece of intellectual property? Because you can have a number of intellectual property from a legal perspective, which helps not only to assist you when there is a particular case, when there is a particular litigation, when someone is using your intellectual property without your permission, without your consent. So it helps you in not only in the courtroom, but right from the beginning, the inception of the business idea. Now we know that if consumers are happy with its product, they will develop trust in its brand and may become loyal customers for all its product. Now when a consumer comes across two otherwise identical products in the market, his choice will invariably move to the branded product of a business that promotes a higher quality, right? Now, many consumers come across and buy a brand, not the product to which it relates, right? So that is the significance of the brand value. Now, what form of intellectual property can protect brand value very effectively? That is what I'm going to discuss in the subsequent slides. Before doing that, let us understand which are the most valuable brands, right? So first I am explaining, first I'm discussing about the most valuable brands globally, which were considered to be the most valuable brands in 2019. So I have relied on the Forbes reports. I have mentioned the URL in the bottom of the slides. So you can have access to that particular website and you can check that. So you can see that the top most valuable brand in 2019 was Google, followed by, sorry, I'm so sorry. The most valuable brand in 2019 was Apple, followed by Google, Microsoft, Amazon, Facebook, Coca-Cola, Samsung, Disney, then Toyota and McDonald's. So you can see the brand value of the respective brands on the right hand side of the respective brand. So for example, the brand value of the trademark Apple in 2019 was $205.5 billion. So you can understand why a particular business organization will be interested in protecting the brand value, right? So this is globally what is considered as the most popular brands. Now next I will be talking about the top 10 most valuable brands in India for the last year, that is in 2019. So the Tata Group of Industries, so we know that there are different areas where Tata Group has entered into. So Tata Group is considered to be the most, the trademark and the brand of Tata is considered to be the most valuable brand sorry, in India in 2019. So what is the brand value of Tata Group? What was the brand value of Tata Group in 2019? It was $19.6 billion, followed by Life Insurance Corporation, then Infosys, State Bank of India. In number 5, there is Mahindra Group, which where the brand value is $5.3 billion. Then HDFC Bank, Bharti Airtel is in the 7th position, followed by HCL Technologies, Reliance Industries, and Wipro. So you see that when you immediately see the particular trademark, it creates an image on our mind, and that is the importance of brand value. And that is why the business organization should have an important understanding of how to protect this brand value and how to commercially use this brand value and how to stop someone from unauthorizedly taking benefit of the brand value that a particular business organization has acquired, right? So this is the top 10 most valuable brands in India in 2019. Now, before going into details about trademark, industrial design, and trademark, let us see some of the very popular trademark and the history behind it. I am sure all of you will understand what this logo or what this trademark is referring to. This is the Nike logo, or the Nike logo, however we pronounce it. So it's also known as the swoosh. It represents uh, motion and speed. In Greek mythology, Nike is the winged goddess of victory. The mythological association for the brand Nike are flight, victory, and speed. It's not a check mark, as generally we consider that it's a check mark. It's not a check mark. So there are stories hidden behind a particular trademark. So this is a good example of that. The next example, we all know that, especially in this particular time when we are relying on home delivery of several products, so Amazon is helpful for that. So you see the arrow that goes from A to Z. It shows the wide selection of products that online stores sell. So from the trademark, the logo itself, we can understand that what is the purpose or what is the objective of the business that is run by Amazon. Next, we'll talk about Adidas. So Adidas has two variants of its trademark. So earlier you can see that the three-leaf shape trademark was there, which is meant to represent the main land masses of the Americas, Europe, and Africa and Asia respectively. The intersecting lines across the three forms signify diversity. But now we see the first trademark which you have. It symbolizes a mountain, that is a metaphor for the challenges and perseverable goals that all athletes must meet. We also know that the Adidas is a short form of All Day I Dream About Sports. So this is a good example that where a trademark reflects the objective of the business organization. Next is IBM. The white lines passing through IBM's logo represents the equality above all else, right? So after that, I want to talk about Vio. It's a product. It's a trademark owned by Sony. I hope you know that. I'm sure all of you know that it is a popular brand which sells computers. I mean, especially laptop. So you see the trademark here. I'm very sorry for that. It may appear to you as a fancy way of writing the letters Vio, but the story behind the picture is that it shows that the hidden meaning behind the way it's written. So you see that the way V and A, that's how we understand, that's how analog is, the analog mode is represented, and 1 and 0, the binary code, the digital code, that is how is represented to that particular in respect of this particular trademark. So although we consider it as Vio, but very smartly the analog and digital mode is reflected through this particular trademark, right? Now, after we understand that how intellectual property rights can be relevant for business, how intellectual property rights can be used as a tool and technique for protection in case of business, I just want to go through the important aspects of protection of trademarks under the legislation, that is Trademarks Act 1999. Now, I understand that considering the audience of this webinar, I will not be using the legal expression, but I want to explain that this is the main law, the main legislation which exists in India in respect of protection of trademarks. So for each type of intellectual property rights, there is separate legislation that has been enacted by the Parliament of India, right? So for protection of trademarks, which is a primary instrument for protection of brand value, the Parliament has passed this law called Trademarks Act in 1999. So this Trademarks Act tells us what can be considered as trademark, what trademarks cannot be protected under the law, and what are the rights a trademark owner has, and if someone uses someone else's trademark without the permission, what are the remedies that can be availed by the proprietor or the owner of a registered trademark. So in subsequent few slides, I will be highlighting the important aspect of the law. So I'll try to focus on what can be protected as trademark, what cannot be protected as trademark, what are the good qualities of registering a particular trademark, where to register a particular trademark, and if someone uses a protected trademark without consent, without authorization, what would be the consequences of that, right? Just a second. Okay, I'll take the questions later, maybe.
Yes, sir. We have the question and answer sessions at the end of your talk. We'll
Okay.
take the questions at the end.
So till what time I'll continue my presentation? For another half an hour, maybe?
You could go up to 1 o'clock.
Uh,
You have got half an hour, yes?
Okay, fine. So I can continue my presentation for another half an hour, then I'll take questions maybe.
Okay.
Okay, thank you, Father. Okay, so now I think by this time we are convinced, all of us are convinced that how intellectual property rights are relevant for an entrepreneur in respect of starting the business and expanding the business, and when, because that is how the brand value can be developed, and that is why it is necessary to protect the brand value as well. So what are the different techniques for that? So that is why I am starting with the technical aspects of it. So
Hello, doctor.
I'll try to.
Doctor,
Sorry,
you can talk for 45 minutes. You have still time.
I can talk for 45 minutes. That is fine. Okay, thank you, Father. Thank you, Father. Okay, so I'll try to simplify the language and try to present in such a manner that it is so that it is understandable for all of us. So I'll start with the definition of trademark, because understanding the definition of trademark under this particular legislation will help an entrepreneur to understand what falls within the definition of trademark and what does not fall within the definition of trademark, right? So when I'm starting a business, the first thing I will be requiring is a name. That is what exactly the purpose of trademark, right? So in respect of having a particular trademark, I should also be careful about whether that particular trademark is existing or not, because the trademark which I want to register, if it is registered by someone else, then I cannot register it. So I need to find out that whether my trademark is already being registered or not. So I'll tell you later how to do that particular search. But before that, we should know that what are the attributes of a good trademark. So in order to, trademark means a mark which is capable of being represented graphically, right? And which is capable of distinguishing the goods or services of one person from those of others, and it may include the shape of goods, their packaging, and combination of other colors. Sorry. Now this is the legal definition given in the statute. So what does it signify? When we say that a mark is capable of being represented graphically, it simply means that it should be visually perceivable, so that you can see that particular mark, right? So it should be fixed in some permanent form. It should be a logo, it should be a symbol, something which is tangible in nature, if I can simplify it. Although we say that intellectual property rights are subset of intangible asset, and intellectual property rights are intangible in nature because it is the creation of our mind, and that's why it is invisible. But when you want to register your trademark, when you want to enforce your trademark, it is necessary that that particular trademark is visible by all, so that the trademark is seen by to all of us. So that's why the law says that it should be capable of represented graphically, means it should be visually seen to us. It should be in the tangible form. That is what it signifies. And what is the second aspect of it? Which is capable of distinguishing the goods or services of one person from those of others. If we now let me give an example. If two persons have identical name, of course there will be a difficulty in identifying either of them. So it is necessary that there has to be some distinguishing element. So that's where we go further and see that that what is the address and other factors in order to make a distinction and identify the correct person. So that's why in case of trademark protection also, it is necessary that the trademark which you want to protect, which you want to register, is distinctive enough. Means that why it is important, so that when you are going to the market and you want to for example you want to buy toothpaste, and if there is no distinguishing trademark, you will not be able to identify that particular that particular toothpaste which you want to buy. For example, I have an inclination for Colgate. So if how when I go to the market, how do I identify that this is the toothpaste which is manufactured by Colgate Palmolive? How do you understand? By looking into the distinctive trademark of Colgate. So Colgate is distinctive from Anchor, Colgate is distinct from Pepsodent and other brand. So that is why the trademark should have its distinctiveness. This is the key legal word that we focus on when we talk about protection of trademark. And this is the word, that distinctiveness. This word is emphasized by the Comptroller General of Trademark also when we apply for trademark registration before the authorities, right? So two important things of the definition of trademark. First, it should be tangible, that it should be visible to all of us, and secondly, it should have distinctiveness, right? So these are the two requirements which you have to keep in mind when we intend to register a particular trademark. Next, in order to be trademark, we need to understand what is a mark, right? If the mark falls under the definition of this particular law, then only it becomes a trademark site. That is how we perceive this particular aspect. Now, what do you mean by mark? Mark includes a device. Here, device does not mean an instrument. Here, device means a particular image, right? So it can include a device, a brand, a heading. It can include a label or a ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination of colors, or any combination thereof. So these are considered to as mark for the purpose of this particular law. If the mark which you are intending to protect falls under any of this, then only it qualifies to a trademark. So what examples can we get for this mark? So on the right hand side, you can see that there are a couple of trademarks which are mentioned. So first is MRF. It's an example of the first one. It's a composite mark actually. What is a composite mark? Composite mark is those marks which are a combination of both an image and a word or letter. So we can see that the abbreviation, that is MRF. I'm sure all of you know what is the full form of MRF. That MRF stands for Madras Rubber Factory. So this is a combination of an image, a person holding the tire, and the letter, that is letters, that is MRF. So it's a composite mark. It can be simply an image. If you can see the penguin logo down, so that is an example of a trademark which is only a particular image. So the penguin logo, the moment we look into we see this particular trademark, we know that we are talking about something which is related to the publishing industry or publishers, right? So this is a mark. So first of all, in order to be a trademark, first of all, it should be a mark. So what is a mark? It can be an image as well, right? It can be numerals. So if you can see on the bottom left corner, there is a image of Superpower 555 detergent cake. So a numeral can also be considered as mark for the purpose of this particular legislation. It can be a signature. It can be a word also. For example, Paytm, right? So this is a subject matter of mark. Yahoo, it is again it's a word, so it's a simple word, right? That is protected. But here is an interesting fact about Yahoo. Yahoo has registered this particular word mark. You can see that there is a small R on the right hand side of that particular trademark, and that signifies that the mark is registered. in some places you will see that the word TM is written. So those that particular instance signify that the particular trademark is being applied for registration, but it is not registered as yet, but that trademark is in use. So the word TM signifies that the trademark is in use but not registered yet. But if you see the R in the circle, it signifies that the trademark is registered. So Yahoo Incorporated has not only got a registration of the Yahoo word, but also it has got a sound mark registration, right? Sound mark registration for the doodle, for the yodeling of Yahoo. So you know how Yahoo is pronounced, right? So that sound is also registered as a trademark. Now you may ask that how come sound gets a protection as a trademark when sound is not considered as mark? That's why sound is considered as non-conventional trademark. Generally in India, sound marks are not registered, but after 2017, even sound mark can be registered in India. But before that, in India, there was no provision for registration of sound mark. But after 2017, it is possible. Now, you can also see the image of Levi Strauss and Company. So this is an example of a label as a trademark. So it's a very popular trademark in respect of clothing industry. So especially in case of jeans. So that's why you see that this label can also be considered as mark. So these are some of the examples, not an exhaustive illustrations of what can be considered as mark, but precisely mark can be a device, it can be a brand, it can be a heading, it can be label, a ticket, name, it can be a signature, word, letter, numeral, shape of goods, packaging, or combination of colors, or a combination of any of this. So it can be a combination of an image and a name, right? A combination of a image, device, and word. Tata is a good example of that. So you can see that the image is there, which is signifying that a road being splitted on in two sides, and also in a way that it signifies the word T, right? And the word Tata. So it's a combination of both. Combination of colors, what can be an example? If you see the Paytm trademark, so it's a combination of two colors, two shades of the color blue. So it can be a combination of colors also in order to be a mark. So you need to identify that what you're trying to protect as mark falls within this understanding of mark, right? Now, next, we'll talk about the different types of trademarks, which is protected under the Indian law on trademark. Firstly, marks on goods. A very simple example can be the examples which we have seen in the previous slides. Tata, for example. So Tata Salt can be an example of that. Now, what is service mark? Service marks are in respect of those trademarks which are applied in respect of service. For example, FedEx. It's a courier service, so it's that's why it is known as service mark. Although in India we do not make a distinction between trademark and service mark, but for our clarity we can make a distinction between trademark and service mark. For example, Vodafone or BSNL, these are considered as service mark because what they provide is service, not goods. Then Apollo Hospital, right? It's an example of service mark because they provide service. So service mark is a type of trademark protected under this law. Next is certification trademark. Now, what is a certification trademark? Certification trademark signifies that a particular goods is manufactured, a particular goods or a particular service is manufactured or the service is provided following all the necessary compliances. So in respect of food industry, in respect of a food manufacturer, the first trademark which is there in the slide, that is FSSAI, that's a good example of certification trademark. So any food items we buy, there should be this particular certification trademark. Now what FSSAI stands for? Food Safety and Standard Authority of India. So this is the authority which is responsible for certifying that the goods, that the food has been manufactured by following all the necessary conditions, all the necessary compliances, right? So that is what the certification trademark helps us. So when you buy a particular product, whether the particular trademark whether the particular good has been manufactured by following all the conditions or not, you cannot understand that from the trademark. So that's why you need to look into the certification trademark. That is what is the purpose of FSSAI. In the bottom, you can see the example of BIS mark, Bureau of Indian Standards. That is also an example of certification trademark. For example, you are buying a pressure cooker and you don't know that whether that particular pressure cooker is manufactured by following all the necessary rules and regulations, whether the compliances have met or not. So you cannot actually test there that whether the pressure cooker is fit for using in the kitchen or not. But if you see this BIS mark in the pressure cooker, so you get an assurance that the pressure cooker is manufactured by following all the necessary requirement. So that's a guarantee that the particular good, the commodity, is safe for consuming, right? Next is collective marks. What is the purpose of collective marks? The purpose of collective marks is to signify that a group of professionals belong to a particular group. The professional is from a particular category. The professional is from a particular type of profession. For example, the CA, the chartered accountant, this is an example of collective mark. So it can be in respect of the mark which is used by the lawyers, by the advocates. That is also an example of collective marks. So if I am a lawyer, I have registered myself with the Bar Council of India, then I can use the lawyer mark, that is that signifies that I am a lawyer. So if a person has been registered as a chartered accountant, he can use this particular mark, and that will signify that he is a registered chartered accountant. Now, that is what is the purpose of collective marks. It helps us to understand that the person belongs to a particular profession. Now, what is well-known mark? Well-known mark is no different from, is not a very distinct type of trademark. It's a trademark actually, but well-known marks are those marks which is recognized under this act, where the mark is not registered or maybe registered, but it is there for a long period of time. So Bata is an example of a well-known mark, right? So it is there in the, you can see that the mark now is registered, the R symbol is there, but even if the R mark is not there, no one can, even if it is not registered, no one can use a similar mark because it is considered as a well-known mark. So these are precisely the different types of trademarks which are recognized under the Indian law. Now, next, after understanding what is a mark and what is a trademark, next you need to understand that whether your trademark is distinctive or not, because this is a very crucial requirement of registration of trademark in India. As I told you, that there are two prime requirements of trademark registration. First, it should be graphically represented, means it should be in the tangible form. And the second requirement is that it has to be distinctive, means it should be different from the existing trademark. As simple as that. How do we understand the distinctiveness element of the trademark? This is a very tricky requirement and we need to be very clear about this. So please, I'll try to explain it as simple as possible. Now, if you can look into the image in this particular slide, on the left hand side, there is a scale, right? If you see that the up we go, it becomes red in color, and the down we come, it becomes, the color becomes blue, right? So the red color signifies that it is a strong candidate for trademark registration, and as soon as you apply for this kind of trademark, you will immediately get a trademark registration. And those trademarks which are mentioned in the blue color, they are generally not not supposed to be registered. They are not registrable generally, but they can be registered provided there is some other requirement which is satisfied. So generally, the trademarks which can immediately be registered, if you apply for registration before the Intellectual Property Office, it will immediately register, and that type of trademarks are three in nature. That is fanciful mark. The first is fanciful mark. That is the strongest category of distinctiveness. So if a mark is fanciful mark, then there's a very good chance that your trademark will be registered. Now, what is a fanciful trademark? From the term itself, it is clearly understandable that the fanciful trademarks are made up words. which are invented to be used as a trademark name. Now, this words does not have any dictionary meaning. So any word which does not have a dictionary meaning is a very good candidate for trademark registration. For example, Kodak. Is there a dictionary meaning of Kodak? No. Does the word Exxon has any meaning for it? So these are invented words. These are made up words. And these invented words or these fanciful trademarks, this type of trademark, are the best candidate for trademark registration. Polaroid is also a good example, right? So the word which does not have any specific dictionary meaning, which is an invented word, which is made up word, that is a good candidate for fanciful trademark registration. The next category is arbitrary trademark. Arbitrary trademark is also a very strong candidate for trademark registration. You can see that both fanciful trademark and arbitrary trademarks are in red color. That signifies that it's a very strong candidate for trademark registration. Now, what is arbitrary trademark? Arbitrary trademarks are words that have a real meaning, that have a common meaning, but they're completely unrelated to the product or service, right? Now, what are the examples of arbitrary trademarks? For the first example will be Apple. Now, please note that if you're selling a carton of Apple and then if you're using this particular logo, then it is not a distinctive logo. But if you are selling electronic items and then if you're using this Apple mark, then it is an important, it's a very good, very strong candidate for trademark registration, because the word Apple has nothing to do with electronic items. So what is arbitrary trademark? The word has nothing to do with the products or service that is being sold or that is offered, right? So Apple is a good example of it. Dove is a good example of that. Dove is used, the trademark is used in respect of selling soaps, right? So it is very unlikely the bird will actually use the soap, right? So that is why it is totally unrelated to the class of goods that is being used. So the Shell trademark, which is on the right hand side, which is used in respect of selling petroleum and diesel, that is a good example of arbitrary trademark. So any trademark which is an invented word or which has nothing to do with, which is not related to the product which is being sold or the service which is being offered, is a very good candidate for trademark registration. Next is suggestive trademark. This is a very tricky part, because you see that the next type of distinctiveness is descriptive trademark, and which is in blue. Blue means these are weak candidate for trademark registration, and we should not have those kind of trademark. But suggestive trademarks are in the category of strong trademark, but the color which is there is not absolutely red, right? It is a strong candidate, but not that strong candidate. But what do you mean by suggestive trademark? Suggestive trademarks are named after a characteristic of the product or service. So it is not not directly describing the quality of goods or the service being offered, but it is indirectly telling us about the quality of the service. What can be an example of it? The first example, Jaguar. Jaguar, the animal signifies speed, pace, right? That's why it is used by a car manufacturing company. So if you are using the word speed in respect of a particular vehicle or a car, then it may not be registered, because that is the word speed is designating the type of service or the type of product that you are selling. But if you are using the word Jaguar, then you are indirectly talking about the quality of the goods you are selling, but you are not describing the goods which you are selling or the service which you are offering. So similarly, Microsoft and Netflix, these are all examples of suggestive trademarks. So it is suggesting what kind of goods they are, what kind of service. Microsoft and Netflix, both of these are service mark, because of course they're providing service. So you need to see that they are suggesting the type of service they're providing, but they are not describing it. So Jaguar, Microsoft, Netflix, these are examples of suggestive trademark. Suggestive trademarks are good candidates for trademark registration. What are the next two categories? That is descriptive trademarks and generic trademarks. What are descriptive trademarks? Descriptive trademarks are a description of the product or service, right? So if you're selling water bottle, and you are you intend to register the word water bottle for selling the particular product, your trademark will not be registered, because water bottle is describing the goods, the product which you're selling. So sharp, in respect of television, it is describing the particular type of product which is being sold. British Airways, Best Buy, these are all describing the quality of service. But then your question will be, how come they have got trademark registration? They have not got trademark registration as such, but based on its continuous usage, they have acquired distinctiveness over a period of time. And when in technical language we use the word secondary meaning, it means that when you talk about sharp, we know that it is not describing the goods, but it is talking about a particular brand of television. Again, an example, Maruti Swift Desire. Here the word Swift is describing, right? It's a descriptive word, but how Swift Desire has got a trademark registration? So over a period of time, when we see the word Swift in respect of a car, you know that it is not used as a descriptive sense, in a descriptive sense, but it is used in respect of a particular car. So even though descriptive trademark is not a very strong candidate for trademark registration, is rather a weak candidate for trademark registration, if it has acquired distinctiveness over a period of time, then it can get registration, otherwise not. Generally, descriptive trademarks are not that good candidates for trademark registration. If you are selling say a scooter, or if you say you're selling a ceiling fan and you are using the trademark fan for that matter, that's a descriptive mark. But if you're using the trademark Usha for selling ceiling fan, so in that case it will not be a descriptive mark, so we need to be careful about it. And the last category is that of generic trademarks. Generic trademarks, as we can see that they cannot be protected as they simply a generic description of the product or service. Band-Aid, aspirin, thermos, they're good examples of generic trademark. Now initially what can happen is, I have not mentioned a very good example here, Xerox, will come to that later. Generally sometimes a particular trademark which is not otherwise generic, but over a period of time, if it becomes the use of that mark becomes generic in nature, then it may lose its distinctiveness. Many a time we have seen that people are referring to Godrej as when they are buying Almira. So when they are buying Almira, but they are buying Almira not manufactured by Godrej, but they are referring to as Godrej. Why they do it? Because the Almira manufactured by Godrej is very is very convenient. Is very, the quality of the good product is very good. So that is why the word Godrej may become generic for selling Almira, right? Similarly, aspirin is nothing but a particular type of medicine, right? It's a brand name of that, but because of overusage of the word, it has become a generic. It is basically a paracetamol tablet. The aspirin mark is the brand name of it, but the word aspirin has become a generic mark for paracetamol tablets, right? For example, another example can be, we use the word what is that? Elevator. Okay, I'm sorry, I am not remembering. I'll give another example, that is Xerox. Xerox is nothing but an instrument for photocopy, but Xerox has become a synonymous name for photocopy. But then there was a particular litigation which happened in India, and the authority declared that Xerox is not a generic mark. But when a particular mark becomes generic for descriptive and generic in nature, there is a good chance that it may be refused for registration until unless you can prove that it has got acquired distinctiveness, right? Now, so generally, in respect of selecting a good trademark, what are the things we should keep in mind? We should go for a trademark which is easy to speak and spell. In case of wordmark, it should be appealing and easy to remember or recollect. It should be an invented or coined word, or a unique monogram or logo, or a geometrical device. But there are certain aspects which we should keep in mind while we are going for registration. A trademark which is not capable of distinguishing your goods or services from those of others cannot get trademark registration. For example, two-digit letters or numerals, a common surname, right? Names, words, or pictures of the product. They are generally not registrable, but if you can prove that it